The game is on, and the ball is in special counsel Jack Smith's court in terms of Trump's ongoing effort to delay his federal election interference case over a bogus claim of presidential immunity. This morning, the Supreme Court responded to Trump's request to put on hold the last week, the D.C. Circuit Court of Appeals, their ruling that rejected that immunity claim. He wants to stop it. He wants to stop everything in order to hear more about why his claim was rejected. Chief Justice John Roberts is giving the special counsel 1 week to respond to Trump's request, even though it's unlikely that Smith's team is actually going to take that long. But the bigger question here, the one that everybody's wondering, is what exactly is the Supreme Court going to do next? Joining me now to discuss all of this is former federal prosecutor, my friend, and super lawyer, Glenn Kirshner, MSNBC legal analyst and host of the Justice Matters podcast. Sir, I have not been able to take off my glasses the entire night. We've had a big one in terms of news, but now I get to talk to a lawyer and finally do that. First and foremost, what are the chances that Jack Smith responds and the Supreme Court says, we're not going to deal with this? Because I'm not convinced that they're actually going to take the case and review it at all. But you may think,
okay, stop everything, because what just happened is incredibly significant, like government shaking, presidency changing, political earthquake significant. The United States Supreme Court just delivered a major blow to Donald Trump, and I'm not talking about some small technical issue. I'm talking about two big cases that could deeply change presidential power in America, cases that could remove Trump of some of his most forceful executive tools, cases that the court just decided to take up. And Trump, oh man, Trump's team is in complete panic mode right now because the highest court in the country just said, yes, we need to examine what you're doing. We need to decide if you've crossed the line. And that alone is huge. That alone suggests that even Trump's own Supreme Court picks may be growing uneasy with how far he is expanding executive power. But before we continue, let's be real. You can't truly rely on headlines anymore. That's why we created Pump Politics, to bring you real stories, real context, and no corporate bias. If you want to stay ahead of the headlines, sign up for our free newsletter. We'll deliver the news directly to your inbox every day. Just click the link in the description to subscribe. And if you simply want to support what we do, join us and become part of a community that genuinely cares about the truth. All right, now back to the video. Here's what happened. Friday, October 17th, 2025. The Supreme Court announced that it will hear two major cases. Two cases that directly challenge Trump's expansion of power. The first case, Trump versus Slaughter. It centers on Trump firing Rebecca Slaughter, a Democratic commissioner on the Federal Trade Commission. He simply fired her, removed her from her role, claimed he had the authority to do it. But lower courts said, wait a minute, you can't remove independent commissioners whenever you want. That's not how the system works. There are protections in place, separation of powers, and checks and balances. Now the Supreme Court will decide who is right, Trump or the lower courts. And if it rules against Trump, it could overturn nearly a century of precedent on how independent agencies operate. It would fundamentally shift the balance of power between the president and the federal bureaucracy. The second case, and this one is even more extraordinary, involves Trump trying to deploy National Guard troops in Illinois. Yes, federal troops in a Democratic state despite the governor's objections. He argues that he has the authority to federalize the National Guard and deploy them wherever he chooses for public safety reasons. Illinois responded, absolutely not. That's unconstitutional. You cannot deploy military forces into states against a governor's wishes unless there is an insurrection or an invasion. Lower courts sided with Illinois and issued injunctions blocking Trump from deploying the troops. Trump then appealed to the Supreme Court and asked it to lift those injunctions and allow the deployment. But the Supreme Court said no. It declined to block the lower court rulings, meaning that for now, Trump cannot deploy those troops. The court will now review the entire case and decide whether a president has that level of authority. Can you believe it? This is the Supreme Court, a court that includes 3 Trump-appointed justices, telling Trump to slow down, telling him he may have gone too far. telling him there are limits to presidential power. And that's important, really important, because Trump's entire second-term plan has been based on maximizing executive authority, on pushing boundaries, on testing how much power he can grab. And now the Supreme Court is stepping in to say, okay, let's look at that. Let's figure out if what you're doing is actually legal. And that review alone is dangerous for Trump because it creates uncertainty. It limits his ability to act. It gives strength to opposition. It sends a message to lower courts that they can push back too. Justice Sonia Sotomayor wrote a sharp statement. She called Trump's actions a dangerous disregard for constitutional limits. She said no president is above the law. And while Sotomayor's a liberal justice, the fact that the court as a whole agreed to take these cases means conservative justices are interested too. They want to step in. They want to set precedent. And that should worry Trump, because if the court rules against him in either of these cases, it takes away major tools from his arsenal. The power to fire independent commissioners, gone. The power to deploy National Guard troops wherever he wants, gone. And those would be major setbacks. They would fundamentally reduce how much power Trump holds. Legal experts are closely watching this. Deepak Gupta, a well-known Supreme Court attorney, told the New York Times that this term will force the court to decide whether it is actually willing to tell Donald Trump no. And that is the key question, right? We have a conservative supermajority, 3 justices appointed by Trump himself. But does that mean they will approve everything he does? Or will they actually follow the law, actually enforce constitutional limits? We are about to find out, because these cases are not abstract. They are not hypothetical. They involve real actions Trump is taking right now. And the court will have to make a ruling, will have to choose a side. The timing here is also striking because it's happening right as the No Kings protests are filling the streets, right as 7 million Americans are marching against Trump's push toward authoritarian rule, right as Democrats are rolling out their reform and resistance strategy, right as Trump's approval rating is falling fast. It feels like the entire system is pushing back at once. The people, the opposition party, the states, and now the courts. All of them saying, this is too much. This is going too far. This power needs to be checked. And Trump is caught in the middle of it all, trying to fight on every front and losing ground. So yes, this is a big deal. This is the kind of moment that could define Trump's second term, could limit what he is able to get done, could give his opponents more confidence, could shift the balance of power in American government. The Supreme Court has just issued a direct challenge, and Trump is going to have to answer it. And however he responds, whatever happens with these cases, it's going to have huge consequences for the rest of his presidency. Let's get into what's really at stake here. All right, let's break down these 2 cases in detail, because there's a lot of legal complexity here, but it matters. It really matters. First case, Trump versus Slaughter. Rebecca Slaughter is a Democratic commissioner on the Federal Trade Commission, the FTC. The FTC is what's called an independent agency, which means it's supposed to operate free from direct presidential control. That independence is protected by law. Commissioners serve fixed terms. They can only be removed for cause, meaning you can't just fire them because you disagree with their politics or their decisions. You need an actual reason. Misconduct, neglect of duty, something serious. Trump didn't care about any of that. He just fired Slaughter, said she was blocking his economic agenda, said she was too aggressive in regulating businesses, said he needed someone more in line with his vision, and he removed her. Just like that. No formal reason, no process, just executive action. And when Slaughter sued, when she challenged the firing in court, Trump's lawyers made a bold argument. They said the president has built-in constitutional authority to remove any executive branch official at any time for any reason, that the independence protections for agencies like the FTC are unconstitutional, that they go against the separation of powers, that all executive power belongs to the president and he can use it however he wants. Now, this is an extreme legal theory. It's called the unitary executive theory, and it's been around for a while. Conservative legal scholars have pushed it for decades. The idea is that Article 2 of the Constitution gives all executive power to the president. And if all executive power is given to the president, then he must have complete control over everyone in the executive branch. He must be able to hire and fire at will. He must be able to direct their actions. Anything less, the theory goes, breaks the Constitution. It splits executive power in ways that aren't allowed. But here's the problem. We've had independent agencies for almost a century. The FTC was created in 1914. The SEC, the Securities and Exchange Commission, in 1934. The NLRB, the National Labor Relations Board, in 1935. All of them built to be independent, to operate free from direct presidential control. And the Supreme Court has repeatedly backed that independence, said it's constitutional, said Congress has the power to create agencies with this kind of structure. So if Trump wins this case, if the court accepts his unitary executive argument that they side with Trump, that they want a strong presidency, others think the conservative justices, especially the careful ones like Chief Justice Roberts, will be reluctant to throw out a century of established law. Will be careful about giving any president, even Trump, too much power, because precedent cuts both ways. Whatever power you give Trump, you're also giving to the next Democratic president. And conservative justices might not want a future president, AOC or whoever, to have unlimited authority to fire independent commissioners and deploy troops domestically. The National Guard case has an added layer too, because it's not just about law, it's about federalism, about the relationship between the federal government and the states. Conservative justices generally support states' rights, support holding back federal overreach. But Trump's pushing for maximum federal power, for the ability to override state governors. And that creates tension. Do conservative justices side with that? It's a fascinating legal and political question. There's also the image issue. The Supreme Court knows it's being watched, knows that public trust in the institution is fragile. If they're seen as just approving everything Trump does, if they look like party loyalists rather than neutral judges, it damages their credibility, damages their legitimacy. And Chief Justice Roberts cares deeply about the court's reputation, about protecting its institutional authority. So there's pressure on the court to show independence, to prove they're not just Trump's court, they're the people's court, the Constitution's court. And ruling against Trump, at least on one of these cases, would send that message. That executive argument, it doesn't just affect Slaughter, it affects every independent agency, the Federal Reserve, the CFPB, the FCC, all of them suddenly open to direct presidential control. Suddenly, the president can fire commissioners whenever he wants, can direct their decisions, can turn independent watchdogs into partisan tools. That's why this case is so big. It's not just about one commissioner. It's about the structure of the federal government, about whether we have independent institutions or whether everything runs through the president. And Trump's pushing hard for the latter. He wants maximum control. He wants to remove any bureaucratic resistance. He wants every agency reporting directly to him. And if the Supreme Court gives him that power, if they rule in his favor, it fundamentally changes American governance. It creates what critics are calling an imperial presidency, a presidency with almost no institutional checks. Now, let's talk about the National Guard case. This one is even more alarming. Trump's been trying to deploy National Guard troops in Illinois, specifically in Chicago. He says crime is out of control, that the Democratic mayor and governor aren't doing their jobs, that he needs to send federal forces to restore order. And he's using his authority as commander-in-chief, saying he can take control of the National Guard whenever he decides there's a public safety need. Illinois said, absolutely not. Governor J.B. Pritzker issued a statement saying, "We don't want your troops. We don't need your troops. This is a violation of state sovereignty. You can't just send military forces into our state without our consent." The legal question here is complicated. The president does have authority to federalize the National Guard under certain conditions. The Insurrection Act, for example, allows the president to deploy military forces to stop an insurrection or enforce federal law when states can't or won't. But the Insurrection Act has specific requirements. There has to be an actual insurrection or unlawful blocking of federal law or a state asking for help. None of those conditions exist in Illinois. There's crime, sure. Every big city has crime, but there's no insurrection, no rebellion. The state is not asking for assistance. In fact, the state is actively opposing the deployment. So Trump's lawyers are making a different argument. They say the president has inherent authority as commander-in-chief to deploy forces wherever he believes there is a threat to public safety, that he does not need the Insurrection Act, and that his constitutional role gives him broad discretion. But the lower court said, no, that's not how this works. You cannot deploy military forces inside the country whenever you decide to. That is what separates democracies from military dictatorships, civilian control of the military, and limits on domestic deployment. The entire system is built to prevent presidents from using troops as a political tool. And the Supreme Court, at least for now, agreed with the lower courts. They refused to lift the injunctions, which means Trump cannot deploy those troops while the case is still pending. And that is significant because it shows the court is taking the constitutional concerns seriously. They are not automatically siding with Trump. They are actually examining whether this expansion of power is legal. And the fact that they are reviewing the case at all suggests they believe there are real questions here, real concerns about what Trump is trying to do. Sonia Sotomayor's statement was sharp. She did not hold back. She said the administration is showing a dangerous disregard for constitutional limits. She warned that allowing this type of deployment would create a troubling precedent, giving future presidents the ability to use military force against domestic political opponents, against protesters, and against states that disagree with them. She invoked the principle that no president is above the law. And while she is in the ideological minority on the court, her words carry weight. They shape the debate. They put pressure on the conservative justices to take the constitutional question seriously. Now, here's where things get really interesting. The court has scheduled oral arguments for Trump versus Slaughter on December 8th. That is less than 2 months away, which is unusually fast for the Supreme Court. Normally, cases take longer to reach oral arguments. The fact that the court is moving quickly suggests it understands the urgency, understands that this is affecting government operations right now. And a decision could come as early as spring 2026, just before the midterm election season begins to intensify, which means the political stakes are enormous. If the court rules against Trump, it energizes Democrats, validates their reform and resist strategy, and shows that institutional checks on Trump's power still function. But if the court rules in Trump's favor, if it grants him these expanded powers, it becomes a green light for even more aggressive executive action. It tells Trump he can push harder and go even further. Legal experts are divided on how this may unfold. Some believe the conservative justices, okay, let's break down what all of this means and why it matters so much. Because we are not just talking about legal details here, we are talking about the basic structure of American government, about how much power a president should have, and about what kind of country we want to be. Point 1, the Supreme Court has put Trump on notice. By agreeing to hear these cases, and by refusing to immediately side with him on the National Guard deployment, the court is sending a message. And that message is, we're watching. We're going to examine what you're doing. We're going to enforce limits. And that alone is significant because Trump's entire strategy has been built on the assumption that he can push boundaries without consequences, that the Supreme Court, with 3 of his own appointees, will support him. But now there is doubt, now there is uncertainty, and that changes Trump's calculations. Think about it from Trump's perspective. He fired Rebecca Slaughter believing it would stand, believing no court would reverse it. He tried to deploy troops in Illinois, believing the Supreme Court would allow it. And now both of those assumptions are being challenged. Now he has to defend his actions in court, has to make legal arguments, has to persuade justices who may not be persuaded. And while all of that is happening, he cannot take similar actions elsewhere. He cannot fire other independent commissioners. He cannot deploy troops in other Democratic states, because if he does, he faces the same legal challenges, the same uncertainty. So even before a final ruling, simply by taking these cases, the court has limited Trump's ability to act and created a chilling effect on his executive overreach. Point 2, the unitary executive theory is finally facing a real test. For decades, conservative legal scholars have promoted this theory, but it has never been fully tested at the Supreme Court, never definitively resolved. And now it will be. The court will decide whether the president has unlimited removal power over executive branch officials. And whatever they rule will set a precedent for generations. If they say yes, if they accept the unitary executive theory, it fundamentally transforms how the federal government operates. Independent agencies would lose their independence. Everything would fall under direct presidential control. Regulatory agencies would become political instruments. The Federal Reserve could face pressure on interest rates. The FTC on antitrust enforcement, the SEC on securities regulation, all of it exposed to presidential influence. But if the court says no, if it rejects the unitary executive theory, it preserves the current system and keeps these agencies independent. And it tells Trump and future presidents there are limits. You do not have unlimited power. You cannot simply fire people because you disagree with them. You have to respect the structures Congress created. And that is huge. That is a major check on presidential power. That ensures that at least some parts of the federal government can function independently, can resist political pressure, and can do their jobs without fear of being fired for upsetting the president. Point 3. The National Guard case is about stopping military authoritarianism, and we need to be clear about that because what Trump is trying to do in Illinois is not normal, is not acceptable. Sending military forces into a state against the governor's wishes when there is no insurrection, no rebellion, no emergency, that is authoritarian behavior. That is what dictators do. They use military power to crush opposition, to intimidate political opponents, to control areas. And American law is specifically built to stop that. We have strict limits on domestic military use, precisely because the founders understood the risk of standing armies being used against civilians. If the Supreme Court allows Trump to deploy troops in Illinois, they are opening a door that should remain closed. They are saying any president can send military forces into any state whenever they decide there is a public safety issue. And who decides what counts as a public safety issue? The president alone, without oversight, without checks. So a president could say, there is too much crime in this city, I am sending troops. Or, there is too much protest activity, I am sending troops. Or, this state is not enforcing laws I like. I am sending troops. It becomes a tool for political control, for federal pressure over states, for military intimidation of civilians. And that is frightening. That is the kind of power that breaks democracies. So the Supreme Court has to get this right. They have to uphold the lower court injunctions. They have to say no to Trump. Because if they do not, if they give him this power, we are in uncharted and dangerous territory. We are talking about a basic shift in American government, a shift toward authoritarian rule, toward military control. And once you go down that road, it is very hard to return. Point 4, this connects directly to the No Kings movement. Remember, 7 million people just protested against Trump's authoritarian tendencies. They were chanting, "No kings, no dictators." They were calling for limits on presidential power, and now the Supreme Court is examining exactly that. Is Trump acting like a king? Does he have unlimited authority, or are there constitutional limits? The protesters in the court are asking the same questions, from different angles, but pointing to the same issue: executive overreach, authoritarian behavior, and the weakening of democratic norms. And if the court rules against Trump, it validates the protesters. It says, "You were right to be concerned. You were right to demand limits. The system is working. The checks and balances are holding." And that energizes the movement, makes them feel heard, makes them believe that resistance matters, that organizing matters, that speaking out makes a difference. But if the court rules for Trump, if it grants him these expanded powers, it tells the protesters they need to fight even harder, that the courts will not save them, that they need to win elections, flip Congress, and change the political landscape. Either way, these Supreme Court cases fuel the opposition movement, either by confirming their concerns or by showing that electoral action is the only answer. Point 5. The political timing is crucial. Oral arguments in December, a likely decision in spring 2026, right as midterm campaigns are heating up, right as voters are focusing, right as candidates are making their messages. If the court rules against Trump, Democrats gain a powerful talking point. They can say, "See, even the Supreme Court says Trump went too far. Even conservative justices recognize he is violating the Constitution. Vote for us to add more checks on his power." It becomes a gift to Democratic campaigns. It confirms everything they have been saying, energizes their base, and persuades independents. But if the court rules for Trump, Republicans get a lift. They can say, "The Supreme Court backed the president. His actions are constitutional. The left's been lying to you about authoritarianism. It's all fake outrage." And that could help Republican candidates, could reduce Democratic turnout, could swing close races. So these cases aren't just about legal principles. They're about political power, about who controls Congress after 2026, about whether Trump's second term is empowered or held back. There's also the question of how Trump responds to a ruling against him, because Trump doesn't like losing, especially doesn't like being told no by courts. If the Supreme Court rules against him, does he comply? Does he respect the decision? Or does he attack the court, call them political hacks, threaten to ignore the ruling? We've seen Trump defy court orders before. We've seen him go after judges. And if he does that with the Supreme Court, if he undermines their authority, it creates a constitutional crisis. It breaks the system of checks and balances because the court has no enforcement power. They issue rulings, they write opinions, but they rely on the executive branch to carry them out. If the president refuses, what happens? We're in unknown territory, in a real crisis of governance. So everyone's watching these cases closely. Legal scholars, political analysts, activists, foreign governments, because the outcome matters, really matters. It determines what kind of presidency we have, what kind of country we are, whether we're a democracy with real limits on power, or whether we're sliding toward autocracy. And the Supreme Court, willingly or not, is at the center of that decision. They're going to have to make a choice, and whatever choice they make, it has massive consequences. Here's the bottom line. The Supreme Court just agreed to hear two cases that could seriously limit Trump's presidential power. One about his ability to fire independent officials. One about his ability to send military forces into domestic territory. Both cases challenge key parts of Trump's executive authority. Both force the court to decide how much power the president should have, and the court has already shown some doubt by refusing to immediately side with Trump on the National Guard deployment. They're taking these constitutional questions seriously. They're going to look at whether Trump's gone too far, and depending on how they rule, it could either enable or restrict the rest of his presidency. This is happening right as millions of Americans are protesting Trump's authoritarian behavior, right as Democrats are rolling out their resistance strategy, right as Trump's approval is dropping. The entire system seems to be pushing back against executive overreach. The people, the opposition, the states, and now potentially the courts. Trump's facing pressure from every direction, and these Supreme Court cases could be the most powerful institutional check yet. Could be the moment the judiciary says, enough, you've pushed too far, we're drawing a line. Or it could be the moment they hand Trump even more power, even more tools to dominate. We'll find out soon enough, but either way, these cases are going to shape American politics for years to come. All right, that's it for today. What do you think? Will the Supreme Court rule against Trump, or will they side with him? Do you trust the court to make the right call, or do you think they're too political? I want to hear from you. Drop your thoughts in the comments. Let's talk about this. And if you made it this far, seriously, thank you. You're the real ones. Hit that subscribe button, smash that like button, because the next few months are going to be absolutely wild. Supreme Court cases, midterm campaigns, ongoing protests, government shutdowns. I'll be here covering all of it, breaking it down, keeping it real. See you in the next one.